The president of our chapter will introduce this evening's speaker.
Great. Thanks, Anne. Hi, everyone. Welcome to our State of Our Democracy lecture series. We are really very delighted this evening and honored to have Dr. Whitney Manzo, who will give us an overview of the US Constitution. Dr. Manzo is currently an associate professor of political science at Meredith College, where she's also the pre-law advisor and the assistant director of the very famous Meredith poll. Dr. Manzo holds a PhD from University of Texas at Dallas in political science and methodology. While her general area of expertise is American politics, her further expertise include areas such as public opinion and constitutional and electoral laws, elections, gender issues in politics. Dr. Manzo's research agenda focuses on the imbalance of power and issues, and issues of representation. She is currently working on a book chapter about views towards women in elected offices, and has a couple of projects about women in North Carolina politics. Dr. Manzo has served as the president of the North Carolina Political Science Association. She's also a very active member in the American Political Science Association, the Southern Political Science Association, and the Southern Association for Pre-Law Advisors. Please help me welcome Dr. Manzo.
Hi, everyone. Thank you so much for having me. Thank you to Krishna for inviting me. And as she said, I do a lot of research on women in North Carolina politics. So I'm very, very excited to be here with you all tonight. So I will go ahead and share my screen. So for tonight's talk, I have two sections. The first section is going to be a refresher on the Constitution and the Bill of Rights and other important amendments. And then the second part of the talk is going to talk about civil rights and where we have civil rights in the Constitution. Do we have civil rights in the Constitution? And what can we do if we want to protect and expand on our civil rights? So, just a quick refresher of the Constitution and the Bill of Rights and other amendments. We have in our Constitution, which is not a very long document, only 7 articles. The Bill of Rights are technically amendments, so they're tacked on at the end. The first article and the longest article is about Congress and what the powers of Congress are, how Congress people should be elected, and the areas that Congress does not have power over. And it's the longest article because the Founding Fathers considered Congress to be the most important branch. They thought that the legislature, which would come from the people, and at the time that the Constitution was adopted, the House of Representatives was the only part of our government that was elected directly by the people. Now we elect senators too, but at the time it was only the House of Representatives. So that's why they thought that Congress should be the most important. It would be the one that is the most closely connected to the people. Article 2 was the executive, which was totally new when they wrote out the US Constitution, because the original founding document of the United States, which was the Articles of Confederation, did not have an executive in it. That was actually one of the problems with the Articles of Confederation, was that there was no centralizing figure who could help all of the states work together on issues of common concern, like war, either within the United States or from foreign countries outside of the United States. Also money, Under the Articles of Confederation, each state had its own money, and that was really confusing. And so the executive was a new creation for our government. And it was George Washington who determined that he wanted to be called president as our first president. And the Article 2 just lays out the areas that the executive should be in charge of. And they are mostly centered on things that can represent the entire United States, specifically dealing with like foreign treaties or ambassadors. And then the shortest article is actually, or the shortest article about a branch of government is Article 3, the Judiciary. And all it really says is that there's going to be a Supreme Court and then whatever other courts that Congress wants to establish. So the Supreme Court is the only court that's named by name in the US Constitution. And it was considered by the founding fathers to be supposed to be the least important branch. As we will see, that's not how it ends up. But at the time, that's how they thought it should be, because the judiciary was meant to be unelected and have a lifetime appointment. And so the founding fathers thought that that was the most removed from the American people, and therefore that branch should be the least powerful branch. A couple of other articles in the Constitution lay out how the states should interact with each other. And importantly for our talk today, the amendment process, that's Article 5 of the Constitution, talks about how to amend the Constitution. There are two paths that I will show you later in the talk. Article 4 deals with how states should respect each other's decisions. That's called the full faith and credit clause. And what that does is recognize, for example, if you're married in North Carolina, then you don't have to get remarried if you move to California. California will accept your North Carolina marriage certificate. And similarly, if you live in North Carolina and you decide you'd like to go on vacation to Walt Disney World and you need to rent a car, then Florida will accept your driver's license from North Carolina. So the full faith and credit clause means that acts that are considered official in one state should be considered by the other states to be official. The privileges and immunities clause is important because it says that no one state can privilege their citizens over another state's citizens. So what this means is North Carolina could not pass legislation saying, if you're born in North Carolina, you don't have to pay any taxes, but everyone else has to pay 15%. Because that would be privileging their quote unquote citizens over the other citizens of the United States. So states aren't allowed to do that under the privileges and immunities clause. And then the last article I'm going to bring up is Article 6, which is important because it is the Supremacy clause. And it says that the federal government is supreme to all of the state governments. This was pretty controversial at the time that the Constitution was adopted, because under the Articles of Confederation, all of the states were equal and there was no one centralized government. But they saw that it was hard when you have a confederation of wholly equal states and one state can veto and then everything dies, then it's not very easy for the government to move forward at all. And in case you were interested, Rhode Island was the state that always vetoed everything. So it meant that they never moved forward on things they needed to move forward on. So they wrote into the Constitution that the federal government, the newly created federal government, was going to be supreme to the state governments. And the anti-federalists hated this, hated it a lot. And that's actually how we get the Bill of Rights. Part of the tussle over whether we should ratify this new Constitution included a pretty strong movement from a group called the Anti-Federalists, who objected to the fact that there was no protection for states or their citizens in the Constitution. And so during this ratification battle, if you've seen the musical Hamilton, they kind of talk about it there. They had, in New York was the center of the fight. And Alexander Hamilton, John Jay, and the third one is escaping me, James Madison? well, there were three of them. Alexander Hamilton wrote the most. They were trying to convince New York to ratify the Constitution. And one of the things that they promised, I think it was James Madison, it was, because he wrote Federalist Number 10. And he promised that if New York ratified the Constitution, he personally, at the very first Congress, would propose a Bill of Rights to protect the states and to protect citizens from this new government. Sorry for my little moment there, but yes, it was James Madison, Alexander Hamilton, and John Jay who wrote the Federalist Papers. And they were designed, again, to ease everyone's concerns about the Supremacy Clause that's in Article 6. The other part of Article 6 that's important is that all officials of our government have to swear an oath to this Constitution, that they will uphold it. And it's not just people in Congress or the president either. Everyone who serves in a state legislature or in a city council also has to swear an oath to this Constitution, swearing that they will uphold it. And Article 6 also contains the only mention of religion in the original Constitution. And it says that there shall be no religious tests in order to be an official of the American government. So we do eventually ratify the Constitution thanks to the hard work of the Federalist Papers. And true to his word, James Madison at the very first Congress proposes the Bill of Rights. And these are the first 10 amendments to the US Constitution that are designed to protect American citizens from overreach by the federal government. And the First Amendment is really famous, but a lot of people don't know it actually has 5 parts: the freedom of religion, the freedom of the press, the freedom of speech, the freedom of assembly, and then the actually most important one is the right to petition the government for a redress of grievances. And you might think, well, I object. Freedom of religion is pretty important to me, or freedom of speech is pretty important. But the last piece about petitioning the government is the part that allows you to fight the government if they've abridged your freedom of religion or freedom of speech. If you didn't have the right to present your grievances to the government, then they could just lock you up and there would be no recourse for if they did in fact violate your freedom of religion or freedom of the speech or freedom of press. And so the last piece about the right to petition the government is actually, it goes all the way back to the Magna Carta. It's extremely important to make it so that the government, so that you have a mechanism to fight back when the government infringes upon one of your rights. The Second Amendment is the right to bear arms. It's very controversial. It was very controversial at the time it was adopted because of the usage of commas in it. Depending on if the comma is there or not, kind of changes the meaning of the whole amendment. But the Supreme Court did rule in 2010 that it means that you have an individual right to bear arms. And so that's what it means. Because as we'll talk about later, what the Supreme Court says it means is what it means. The Third Amendment says that you don't have to quarter any soldiers in your home. There's not been a whole lot of Supreme Court cases about this because this amendment was just passed as a reaction to things that happened prior to the American Revolution. And we haven't really had many problems with needing to quarter soldiers in American homes. But we have that right if we need it. The Fourth Amendment is about searches and seizures, and it lays out the requirements for a warrant. So if the government wants to search your house, what do they need to provide? What constitutes an unreasonable search and seizure? And so the Fourth, Fifth, and Sixth Amendments are all about your protections if the government wants to come after you because they think you've committed some crime. So the Fifth Amendment also has your due process of law in it. You cannot be deprived of your life, liberty, or property without due process of law. And that piece is really important because the Supreme Court over time has determined that depriving anyone of their life, liberty, or property without due process of law protects you in a lot of ways beyond just the government can't take something from your home. It also involves how you're incarcerated. It also involves the liberty to get married. So your liberty to get married to who you want to is actually one of the places they located it is in the Fifth Amendment. So it means a lot more than it sounds like it means. And the Sixth Amendment also has several trial protections for you, such as your right to counsel and your right to a speedy trial, which were more things that the founding fathers were reacting to that England had done prior to the American Revolution. The Seventh Amendment involves your right to a jury trial in civil suits. And then your Eighth Amendment is your cruel and unusual punishment rights. So the government can't institute cruel and unusual punishments. And this definition has changed over time. And it doesn't mean, a lot of people think of it in terms of the death penalty, but the Supreme Court has ruled that the death penalty itself is not cruel and unusual punishment. What might be is the way that it's administered, but it can also mean other things. So for example, if someone were to commit treason against the United States, if they were a naturalized citizen, then the Supreme Court says that they can be sent back to the country they came from. But if you are a natural born American citizen and you commit treason, you can't have your American citizenship stripped from you under cruel and unusual punishment, with the idea being that you don't have anywhere else to go. So cruel and unusual punishment actually means a little bit more than just the common discourse about the death penalty. And in fact, in my moot court class that I teach at Meredith, we had a whole semester where we debated whether or not solitary confinement constitutes cruel and unusual punishment. And the different states have decided different things, and the Supreme Court hasn't decided yet. The last two parts of the Bill of Rights are the Ninth Amendment and the 10th Amendment. Your Ninth Amendment is your unenumerated powers. And that was kind of the backdoor for the founding fathers when they said, if we forgot to mention anything, the people still have it. And this is actually where your right to privacy is mentioned, or where it comes from, according to the Supreme Court. You might have noticed I did not say that you have a right to privacy. The word privacy is actually not in the Constitution. But the Supreme Court has said that it comes from, you can tell the founding fathers thought you should have a right to privacy. For example, from you don't have to quarter soldiers, or you are protected against unreasonable searches and seizures. And then the Ninth Amendment being the catch-all of, if we forgot anything, don't hold it against us. That's where your right to privacy comes from. And then and also I want to say the right to privacy has expanded over time a lot to what it means. It originally started with birth control. The very first right to privacy case was about the right of a married couple to have birth control. And it's expanded from there to include the right to abortion. Whether or not it should apply to physician-assisted suicide is a question. And then also your ability to consume recreational drugs in your own home is another right to privacy question. So that phraseology didn't come on the scene until the 1960s, but now it's expanded quite a bit. And its original locus was in the Ninth Amendment. And then the 10th Amendment says that anything that we haven't given specifically to the federal government is reserved for the states. So the states have powers too, and it's anything that we haven't specifically said in Article 1 belongs to Congress, or Article 2 belongs to the executive. And that one was to appease the anti-federalists who said that they didn't like the newly formed powerful federal government. And so they wanted a guarantee that state governments had powers too. And that's what the 10th Amendment is for. As you are probably hearing though, there are several other amendments that are pretty material to our lives. The 13th Amendment abolishes slavery. The 14th Amendment is your due process of law at the state level, and also your equal protection. So everyone will have equal protection of the laws. And I will explain that a little more in a bit. And the 14th Amendment also deals with citizenship. And the 13th, 14th, and 15th Amendments are called the Civil War Amendments. They were passed right after the Civil War. And the 13th Amendment was fairly uncontroversial. The South acknowledged that that was going to happen. And the ratification process had already begun before the Civil War was over. The 14th and 15th Amendments, though, were controversial. And part of the problem was that the Southern states wanted to continue to be able to treat the newly freed slaves as they had been treating them. And they instituted some laws called the Black Codes that were basically just another version of slavery under a different name. So the 14th Amendment was designed to get around that by saying that states could not treat the newly freed slaves as though they aren't citizens of their state. And so the citizenship provisions in the 14th Amendment say that no matter where you were born, where you are living now is your citizenship. So we're all citizens of the United States and the North Carolina. And if I move tomorrow to Texas, I would now be a citizen of Texas, and Texas can't treat me worse for that. And that citizenship piece has become important in terms of if you're born in the United States, that makes you an American citizen, which is a very different way of handling citizenship than many other countries in the world handle it, where you need to be born of parents of that country. We don't have that. We have, if you're born on American soil, you're an American citizen, and that comes from the 14th Amendment. The 15th Amendment included the right to vote for Black men. The 19th Amendment is the right to vote for women, very important. And then the 26th Amendment lowered the voting age to 18 as a reaction to the Vietnam War, with the idea that if you are young enough to fight for us, then you are young enough to be able to vote. So that's just my very quick overview of the Constitution and the Bill of Rights, so that I can set you up for the second part of my talk, which is where we get civil rights in the Constitution and how we could possibly expand on them if we wanted to. So the Bill of Rights is kind of a misnomer. It's not actually your civil rights. We call them our civil liberties because they're really better titled our freedoms. So the Bill of Rights was ratified with the idea that we wouldn't have a constitution if we didn't ratify the Bill of Rights. So it was kind of a political necessity rather than in sincere desire to want to have these freedoms available to American citizens. I take that back. The anti-federalists had a sincere desire to protect American citizens. The federalists went along with the Bill of Rights because they knew they had to in order to get their new constitution ratified. But your civil rights don't come from the Bill of Rights, even though it may sound like they should. These are more like your freedoms. Where your civil rights come from is actually the 14th Amendment. Specifically the piece about due process of law and equal protection of the laws. And the 14th Amendment was originally ratified in order to protect the vulnerable newly freed slaves right after the Civil War. And it was a requirement for states to come back in. You weren't permitted to re-enter the Union if you did not ratify the 14th Amendment. The Southern states did not want to ratify this amendment because they knew that it was going to change things for them. But the federal government said you had to in order to be able to come back. So they ratified it begrudgingly. And it was initially construed very narrowly. The Supreme Court, even though it was written very broad in order to protect the newly freed slaves, the Supreme Court, once the first 14th Amendment cases started to get to the Supreme Court, said, no, this is just meant to protect people from more state action. It's not meant to regulate relations between people. So everyone can be as discriminatory as they want still, as long as it's private action instead of public action. And so the 14th Amendment, even though now it is extremely impactful for your civil rights, it wasn't really construed that way until the 1940s or so. Prior to that, the Supreme Court construed the 14th Amendment very narrowly, and it was a bit of a disappointment of an amendment. The 15th Amendment was the final Reconstruction Amendment, and the intent was to kind of finish Reconstruction so that they could solve, what are we going to do with all of these newly freed people and how are they going to interact in society? The perception on many white Americans' part at this time was that between the 13th, 14th, and 15th Amendments, they've done everything they could to help protect the newly freed slaves, and this should be enough. But similar to how the 14th Amendment was construed very narrowly, so was the 15th Amendment. And let me see if that's next. Okay, no, I'll come back to that idea of how the 15th Amendment was construed very narrowly as an example of how these amendments were put into the Constitution to protect Black American civil rights, and they didn't for a really long time because the Supreme Court wouldn't let them be construed that way. The 19th Amendment was ratified shortly after World War I. Women had been working on the right to vote for a very long time. And in fact, many women's suffrage groups worked with abolitionist groups prior to the Civil War in the hopes that they could get an amendment passed that would allow all women to vote along with Black people. But following the Civil War, when the 15th Amendment was passed, it only mentioned being allowed to vote on the basis of race or color, and it did not include sex. And this was very disappointing to many women's groups because they wanted women to be able to vote too. And it took them a long time to convince the United States that women voting was a good idea. And it took World War I really to convince Americans, enough Americans, that it was important for women to have the right to vote. And there were two main schools of thought on this. The first school of thought was that women worked really hard during World War I to protect the United States while our boys were abroad. And so they deserved a reward for that hard work. And secondly, it was a little hypocritical for the United States to go abroad and say, we're going to fight for democracy. And they didn't let half of their population vote. And so in order to have a stronger moral standing to fight for democracy, that's actually the idea that convinced President Woodrow Wilson at the time, that women should be able to vote. It was in order so that the United States didn't look so hypocritical by saying, you all need to implement democracy, but we don't let some people vote. And so eventually in 1920, women got the right to vote too. So if we have these protections in the Constitution for racial and ethnic minorities and for women, why is there still systemic discrimination and bias? Well, it's all down to, as you might have heard me talking about this during this time, it's all down to the interpretation of the Constitution. The words in the document are ultimately interpreted by us, first at the legislature level, and then secondly, and finally at the Supreme Court. And whatever the Supreme Court says it means is what goes. And so you can have different constructions of the document based on who is sitting on the court at any certain time. And there are differences in kinds of judges. And I wanted to talk about this idea because I hear it a lot in political discourse about activist judges, and that is used to mean liberal, but they aren't actually the same thing. Activism and restraintism is a judge's perception of their role. If you're an activist judge, you think that the judiciary is a co-equal branch to the other two branches, and that it is the job of the judiciary to guard liberties and freedoms and overturn laws if they need to do that. Restraintist judges, on the other hand, and the current Chief Justice John Roberts is a famous example of this, they think that the judiciary should be the third branch, the lesser branch. And the judiciary should only ever overturn something if there's a really obvious problem with it. Otherwise, the judiciary should let laws passed by legislatures go because legislatures are closer to the people than the judges are. So that is one way of looking at your job as a judge, is what is your role? A very different attitude is whether or not you're politically liberal or conservative. And like I was saying, a lot of people conflate these ideas and say activist judges are liberal, restraintist judges are conservative, but it's not exactly true. There are restraintist liberal judges, meaning they have personally liberal attitudes, but they think the judiciary is the least branch. And then you can have activist conservative judges who politically are conservative, but have no trouble overturning laws because they think the judiciary should be equal. A famous example of an activist conservative judge was Antonin Scalia. He had no trouble telling legislatures what he thought they should do, but he was politically conservative. A famous example of a restraintist liberal would be someone like Stephen Breyer, who's currently on the court. He is politically liberal, but he expresses qualms about overturning the democratically elected laws. So there's some similarities and some differences, but overall, between a judge's political ideas and their view of their role can lead to different determinations on what the text of the Constitution says and what amendments say. And what that leads to is different interpretations of your rights. So as an example, I want to tell you about the 15th Amendment to show you how it changes over time. So if you remember, the 15th Amendment was about giving Black men the right to vote. And right after it was ratified, there was a court case about whether or not the 15th Amendment guaranteed a right to vote. And what was especially problematic was the state in question was using literacy tests and poll taxes to keep Black Americans from voting. And the Supreme Court said that you have no right to vote. But if your state allows voting, then they can't treat people differently in the access to the voting. So if you're going to allow voting, you have to mean a poll tax for everyone, or you have to mean a literacy test for everyone. You can't just say only Black Americans have to pay a poll tax. But the main important thing here is a lot of Americans don't know that way back in 1876, the Supreme Court said there is no such thing as a right to vote. Then later, in 1915, in Guinn v. the United States, the Supreme Court said that grandfather clauses are discriminatory. So the very thing that they said was okay, as long as it was equally applied in United States v. Reese, is now not okay. So that's a change. Then fast forward a few years to Grovey v. Townsend in 1935, and the Supreme Court says that private organizations can be discriminatory in primary elections. Grovey v. Townsend was a part of a series of cases coming out of the Texas Democratic Party, who didn't want to allow Black Americans to vote. And they were in court all the time over it. There's like 5 cases in this string of cases. But the most important thing that came out of it first was that because the Democratic Party is a private organization, they can be discriminatory. And then only 9 years later, the Supreme Court reversed course and said, just kidding, you can't be discriminatory at all, even if you're a private organization. And so what I'm trying to show you here is that what the 15th Amendment said did not change over these 80 years. Who was on the court changed, and that changed how the 15th Amendment was expressed. So if there's anything you take away from tonight's talk, practically, it doesn't really matter what the text of the Constitution or the Bill of Rights says, or if the people who wrote them were discriminatory or biased. Whether it matters morally is a totally other conversation that we could have. But practically, what matters is how the Supreme Court interprets the language. So your civil rights and all American civil rights are dependent on how the Supreme Court interprets the 14th Amendment or the 19th Amendment or the 15th Amendment. And that interpretation can change. Over time, the Supreme Court has tended to expand civil rights, but all it takes is 5 justices to say, we don't like that anymore, and the civil rights could be taken away. If you don't like that, how could we move forward? And I have 4 options here for how you could move forward, ranked in order from easiest to hardest to pull off. The easiest thing to do would just be to continue to litigate using our current legislation, like the Civil Rights Act of 1964 or the Voting Rights Act of 1965, and combine those with the text of the current Constitution to say we need to have civil rights for Americans. But the current Supreme Court is overwhelmingly conservative, and many of them are not as protective of civil rights as some people would like them to be. So depending on the courts to protect your civil rights is uncertain outcome, because at any moment, as long as 5 judges are on the side of the decision, then that is what becomes the new law, and all of the civil rights could be taken away. The second option would be to pass new civil rights legislation, trying to make it very clear, this is what we mean by who has civil rights, and not leaving any room for interpretation so that the Supreme Court could not take away anything. But, and I'm going to skip forward, what this is showing you is it's very, very hard to pass legislation in the United States. I've put little bars over every place where a bill can die. And so the bottom is the House of Representatives, the top is the Senate, and bills can die. I think there's 9 in here, 9 different places. So it's a small miracle that we ever passed legislation in the first place. And it's very hard to undo legislation similarly, as we saw when, even though the Republicans controlled the House, Senate, and presidency from 2016 to 2018, they still weren't really able to totally undo the Affordable Care Act, because it's very hard to pass legislation and then or undo legislation. So if we wanted to have the Civil Rights Act of 2021 that was super clear, this is who we want to protect, leaving no room for the Supreme Court to take anything away, it would be a small miracle to get that passed, especially considering that the Senate is evenly divided. A third option would be to amend the current Constitution. Why don't we just add more civil rights? But there's a reason we only have 27 amendments to the Constitution, and that's because amending the Constitution is very, very hard. And in fact, according to constitutional law experts, we have the single hardest amendment process in the world of written constitutions. There are 2 ways to amend the Constitution. The more used way is for a bill to be passed by the Congress that 2/3 of both houses vote for, saying we're going to pass Amendment 28, civil rights for all. After that, that amendment would need to be ratified by 3/4 of the states. That is the way that 26 of our 27 amendments have been passed. The one that has been used once is when 2/3 of the states are tired of inaction by Congress, and they call constitution or conventions in their own little states, and then 2/3 of the states vote for an amendment, and then it goes back for 3/4 of the states to ratify. The only time that has been used was to undo prohibition, by the way. So that was the only one that the states were motivated enough that they bypassed Congress and had their own amendment process. So overall, let me go back to this screen. If you want to continue to litigate your civil rights using current legislation, you're very dependent on the Supreme Court, and that's not great. If you want to pass new civil rights legislation, it's very, very hard. If you want to amend the Constitution, that's even harder. And then the last option is to call a whole other constitutional convention and write a whole new thing. And I'm not going to lie, there are several political scientists who think that this is our only option for moving forward because of so many problems with our current constitution, not the least of which is the Electoral College, but also the composition of the Senate, where you have tiny states like Wyoming with not very many people in them, who have the same representation as states like California, who has hundreds of times that many people. But we can never change the Senate unless all 50 states agreed to it. And if you're a small state, why would you agree to it? So this is some of the evidence for why we need a whole other constitutional convention. But there are, of course, pros and cons to this idea. I was just talking about some of the pros. A lot of political scientists think it would be easier to just start from scratch rather than try to change here and there, especially considering that our amendment process is so hard. And then also there's evidence that engaging in state building increases civic engagement. One of the main problems that a lot of Americans have is how few Americans want to participate in our democracy. And so maybe if we said, we're going to write a new constitution and we want everyone involved, that would encourage some civic engagement. However, there's no guarantee that there would be actual civic engagement because of the current lack of civic knowledge in the United States. And as we've seen since the 2016 election, the vast spread of misinformation that's out there. There's also the problem of all of the issues of special interest money that has invaded politics since 2010, when the Supreme Court decided Citizens United, would almost certainly be involved in this process too. So then you would have potentially a very weird constitution that's preferential to some interest groups and not others. And then lastly, how would we even choose the delegates who would go to such a thing? So there's a lot of logistical concerns too. So we do have options here, like I presented you with. The easiest one, again, it doesn't sound very nice, but it is probably the easiest one, would be to continue to encourage the Supreme Court to have a broad view of civil rights rather than a narrow view. But I want to leave you with what one of the founding fathers said about how we should handle our Constitution, and that's Thomas Jefferson. So if you were wondering how I even picked the title of my talk, it comes from a letter that Thomas Jefferson wrote to James Madison, where he said that at this time, they had written the Constitution and were waiting for it to be ratified. And he said that he was very concerned about how long the new Constitution would last. And do generations have a right to bind one another? And he ultimately said, no, the earth belongs to the living and not to the dead. And he went on to say that a constitution should only last for 19 years, and then we should have a whole new one every 19 years so that each generation can have the constitution that's right for it, and it isn't forced to wear an old constitution like a young man might be forced to wear an old man's coat. So the founding fathers at least thought that we should change up the Constitution as necessary. But which of the four options you think is the best is entirely up to you. And that is all I have. Thank you so much.
Thank you. That was awesome. Thanks so much, Dr. Manzo. I mean, really, I open this up to questions. I don't see any questions in our chat. There's a thank you to you.
I have a couple questions.
Yes.
So mine center, I guess, at the moment around the courts. So if I understood correctly, at the outset, the framers decided that the judiciary would be less powerful because we had unelected officials and they had lifetime, they were on the bench for a lifetime. And so that's their theory. But in practice, now that we've been doing this for a while, have we found that the courts, and specifically the Supreme Court, actually is just as powerful and sometimes even more powerful than other branches of the government?
Yes. So I actually had some students who wrote a whole senior thesis on why the founding fathers would be horrified by our current court's power. And part of it is because they really thought that the courts would just be there for kind of emergencies and to only rectify really horrible situations. And in fact, the power that the courts have now, which is judicial review, so that they have the power to declare something constitutional or not, is not in the Constitution. The Supreme Court took that for themselves in 1803 with the decision Marbury versus Madison. And Thomas Jefferson hated that decision. He was like, this is just a dissertation by the Chief Justice. It doesn't mean anything. None of this is in the Constitution. But then lower courts started citing it, saying, we have the right now, see Marbury versus Madison. And so the courts kind of took a huge power for themselves, and then none of the other branches stopped them from doing it. And now we fast forward 200 years, and the Supreme Court is like, we get to decide things are constitutional or not, and no one challenges them on it. They have that power. And the fact that they have lifetime tenure is also a really big sticking point, because at the time in 1789, when the Constitution is handed down, if you're appointed when you're 65, your life expectancy past that isn't super high. But now, if you're appointed at 65 and you live till 95, you have 30 years to influence the court. And there's a lot of evidence that the founding fathers would never have considered that as something that was a concern, because they thought that of the Supreme Court as kind of like the place you went at the very end of your life of public service. And so that's actually part of why a lot of people now think that we should institute term limits for Supreme Court justices. So it wouldn't be like where we elect people for 4 or 6 years. It would be kind of like the Fed, where you get one 17-year term. And so you're on the court for a long time. You're not subject to political whims, but then after a certain amount of time, you need to step down so that new blood can come on the court and interpret the Constitution. Did I answer your question?
It does, yeah. And so a follow-up to that, then, still thinking in terms of the courts, because it's very hard to pass amendments, and it looks like we would basically never have another constitutional conference. Is it indeed the fact that we do, even though it takes many years, as you just said, the judges are on the Supreme Court for many years, but as they rotate through, they look at cases and they can reevaluate basically something that was said in the past and change it for today. So in doing that, are they keeping it the Constitution pertinent to time? So as time goes by and people's values change, are they keeping the Constitution relevant to the time, I guess?
Well, some of them are, or some of them aim to. And so there's to Dora's question about originalists. This is actually a really good time to answer that. There are some Supreme Court justices that consider themselves originalists, and meaning that they just want to read the text of the Constitution and how it originally read when it was ratified. And they don't want to put any extra meaning into it because they feel like that's too squishy and that it would change too much. And the importance is to have stability in law. The other school of thought is that we should have kind of what you were describing, a living Constitution that can change with the times. And that's part of why it's actually nice that our Constitution isn't more specific, because we can put different meaning into it as times change and our knowledge advances. But these two groups, again, it depends on who's on the court at any one time. You could have several originalists on the court who want to stick to old decisions and old readings of the Constitution, no matter what. Or you could have a court that's more in the living constitutional camp, who thinks that we can change interpretation as society changes. And a perfect example of that tension is the debate over gay marriage. Because it was a 5-4 decision, Obergefell v. Hodges in 2015, and it was a big fight between who thought that the definition of marriage should change as society changes, and the other people who said the founding fathers would never have accepted marriage as between anyone but a man and woman, and that's the only way we should think of it too. And so it really does depend on who, similar to what I was saying about your judicial role, it really depends on who's on the court at any one time.
Right. Thank you.
Sure.
There is a question from Teresa Rosenberg. What are our chances to resurrect ERA? Or will we have to begin again with the ratification process?
And I see where Amy asked that question too. That's actually a really good question, because there is some debate over whether the original deadline put on the ERA is legal or not. So whenever the original ERA was proposed, they put a timeline on it, and then they extended the timeline, but then there still weren't enough states to ratify the ERA by that second timeline. So some people say the ERA is dead. Well, as we know, the requisite number of states have now ratified the ERA. And the 27th Amendment was actually proposed with the Bill of Rights in 1789 by James Madison. So it was proposed in 1789 and it was eventually ratified in the 1970s or 80s. So this is actually a really cute story. When a University of Texas professor was teaching his Intro to American Government class, he told his class how James Madison actually proposed 12 Bill of Rights and only 10 passed. And so the class naturally asked, like, well, what is the other ones that weren't ratified? And one of them was about changing the election process. But one of them was about how representatives shouldn't be able to vote their own raises. So if Congress votes to raise their pay, it won't take effect until the next Congress. And that there was a student in the class who was motivated. He was like, that is a great idea. And he went around and he got the other states to ratify it so that it became the 27th Amendment to the United States. And that piece of evidence seems to indicate that there's not a deadline on amendments. Once something is proposed, it is just there until enough states ratify it, or it just lingers forever unratified. So the real question now, which I imagine some lawyers are working on somewhere, is whether or not the original deadline that was given the ERA can stand in light of the evidence that the 27th Amendment floated around for 200 years.
I have a question. You said that the law, the amendments, it's all about interpretation by the court. But I've been reading about a movement by political scientists about changing the language of the Constitution. Is that a simpler way to go about changing the Constitution? Just simply updating the language?
Well, I mean, it would have to be either through a series of amendments, which, like I talked about, was really hard, or it would have to be a whole new constitutional convention. So
I see.
There are political scientists, I would say many political scientists who study this period and are constitutional law experts really think we need a new constitution, but they don't think politically it will ever happen.
Okay. All right. Thank you. Questions? Any other questions?
I have another question. So Again, looking at where we started with the Constitution, and in practice all these years where we are now, does it seem like Congress has become less powerful over time?
Oh, yes, very much so. And they've given it away. They've handed over much of their power to the executive branch over time. And so the president, I said that the founding fathers would probably be horrified by how powerful our courts are. They would almost certainly be very horrified by how powerful our president is. And there's two ways you can look at it. You can look at it as very bad that Congress has handed so much of their power to the president. But on the other hand, things are much more complicated now than they were in 1789. The world is a lot more global. And if we're going to make the president the person who's in charge of our outward facing activities, over time, our outward facing activities have increased. So it makes sense that the person in charge of that would have more power. But that's a long answer to say that, yes, very much so. Congress now is much weaker than it was originally designed, and it's their own fault.
I have a question relating to HR 1 and its potential impact for voting purposes, since you say the original Constitution, depending on how it's interpreted by the Supreme Court, really didn't have a right to vote in it. And you can reestablish that with the new law. What would be the implications actually from a constitutional perspective of passing HR 1 and also potential lawsuits against it?
So HR 1, the main point of it would be to overturn Shelby County v. Holder, which is a case from 2013 that undid the mechanism by which states have to, it undid the punishment mechanism of the Voting Rights Act of 1965, which the Voting Rights Act of 1965 was probably the single most consequential piece of legislation that Congress ever passed, leaving aside the Bill of Rights, because it helped voting so much in the United States. I mean, immediate impacts that where voting in Mississippi went from 6% of Black people registered to vote to 66% in 1 year. I mean, it was huge. And Shelby County v. Holder undid a lot of that progress by saying that we're not racist anymore. And, you know, Ruth Bader Ginsburg went after Chief Justice Roberts for that one pretty hard. And I agree with her on that one. And so one of the goals, or one of the primary goals of HR 1 is to undo Shelby County v. Holder. And that would be the benefit, if it passed, would be to tell the court, your interpretation in Shelby County v. Holder was wrong. Here's how Congress wants you to interpret it. And so you can do that. Like, Congress does have the power to pass legislation to say even more clearly, here's how we want you to interpret what we're saying. The problem is HR 1 has a pretty low chance of passing because it's so big. It has a lot of provisions in it, and different provisions are popular with different groups of people. I think that the voting rights in this country would be better served by a series of smaller bills that do each thing different, you know, like one a piece at a time. I do think that voting rights in this country for sure should be protected, but that's actually, so I was just thinking while you all were talking or asking me questions, I don't want you to end on a really sad note, like there's nothing we can do. There are things we can do, like pass laws telling the Supreme Court, this is how we want you to interpret things. But it is kind of scary to think that voting rights are up to what the Supreme Court says, and that Congress does have to take some of their power back and tell the Supreme Court, this is what we want you to read this like. And so I think that HR 1 has a low chance of passing. If it did pass, it would almost certainly be challenged right away. And the real question then would be, where would they locate the constitutionality for that bill? Because the 15th Amendment is only about race, and the 19th Amendment is only about gender, and the 26th Amendment is only about age. And we don't really have an amendment that says Americans have the right to vote. And so it would be really interesting to see where that court case would go. But like I said, I'm not sure we would even get that far, because HR 1 has a very high hill to climb to even reach passage.
Any other questions? I have one final question for you. How do you see the young people, the students in your class, react to the language of the Constitution, and how do they interpret it? Do they feel that it's very restrictive? Do they want to open it up more? Or do they see that you can see rights, you can interpret rights within the framework of the Constitution as it stands?
That's a great question. And I actually, I in my intro class, when I teach Intro to American Government, I have it structured as an entire interrogation of the Constitution. And so we spend the whole semester, we learn the basics of American government, but the whole semester is also learning about, like, what does the Constitution say and what do we think about that? And then I end the class with a constitutional convention. And the students over time, so I haven't changed how I teach the topic, okay? But over time, the students have become more and more in, like, we should just chunk the whole thing, because they get very frustrated by the restrictive language, and it feels very exclusive to them. And they dislike that it was written by, a bunch of wealthy white guys in 1789. And in fact, it's really the result of political compromises that were required in 1789. So, like, why should we care today in 2021 about the political fights that these guys were having 200 some odd years ago? And so I do think it's very interesting, because initially when I started teaching this, I'd have a few that were like, let's get rid of the whole thing. But the majority just were like, well, let's just add an amendment or something. And as time has gone on, especially since 2016, I've had more and more say, like, nope, we got to start all over. This thing is not useful anymore. Which isn't my intent going into it. I just want to make sure they know what they're talking about with the Constitution. But I do think it's very interesting. I think that the Gen Z in particular is a lot more radical than a lot of current politicos are ready to hear.
Okay. Ladies, any more questions for Dr. Manzo? Well, if not, thank you so much, Dr. Manzo, for that incredible talk and even more incredible discussion afterwards. Thanks so much.
Thank you so much for having me.
This was great. If there's no other questions, thanks for joining us, but I have two more announcements to make regarding some events that are coming up. Please join us tomorrow at 5:30 for our monthly happy hour, Hot Topics, when Tom Jensen, the Director of Public Policy Polling, will come to us and talk about topsy-turvy world of political polling and discuss what the future holds for political polling. And of course, come back next week on Tuesday for the fourth talk in our democracy series, when Professor Phil Napoli from Duke University will talk about the state of our news media. For both of these events, you can register on our website or on our Facebook page. Thanks again for joining us. Have a good evening. Stay safe. See you next time. Bye-bye.
Thanks again.